There's an issue that comes up a fair bit, more frequently than what you imagine, is whether the employer has the right to change job location and whether the employee may refuse it or does the employee have to accept it and move. So the analysis is similar to any constructive dismissal, and that is, first of all, you look at the contract. What are the contract terms the parties have agreed to? If there's a deal in the contract that there's a move or no move, then there's no contest here. So the real issue becomes whether the employer has the implied right to effect a job relocation. I would have thought initially that that would be a hard argument for an employer to make, but it has succeeded on numerous occasions. Generally speaking, a court will look to the size of the business. Is it international? Are there branches all across Canada? And try to determine, would it be reasonably expected whether the employee should change his or her job location. There is a case involving a large engineering company that, of course, has these mega projects in different locations around the country. And in that case, the court said, yeah, there should be such an implied term. There's also a case involving a Schedule A bank manager. And again, the court said, yeah, the bank should have the right to change job location. So it's a little bit unusual than what you would expect in that the court is examining the context to see if it's reasonable to imply such a term into an employment relationship. In one case, which was not a large company but did have an office in Toronto and an office in Calgary, the company showed that it was a pattern to relocate employees back and forth, and the court did impose the obligation upon the employee to move to Calgary, even though he refused it once before. So you never know is the end result, and it's a big issue if the court does apply that term. Normally, if it's an international relocation, when you're moving from Canada to the States, for example, that's unlikely to be an implied term. There's also other issues involving human rights considerations on this topic, in that human rights laws protect family status issues. So if there is a situation where the employee is caring for his or her elderly parent, and there's obviously a legal obligation to do that, there might be some medical difficulties requiring immediate care, or where the person's spouse is similarly disabled and needs care that cannot be provided in the new city. So these are all relevant issues. Also, marital status is a protected right in human rights law. Perhaps the company is just relocating single people, and being single actually qualifies within marital status. So if there's a pattern like that, then the employee may be able to refuse it. It's a big dice roll when the employee says no, because he or she may be terminated and may not be eligible for severance payments. So this is not the time for you to be driving. Get legal advice. And generally at the outset of the relationship, if the company is a large company across the country, that's the time to negotiate a term at that moment, to say, okay, look, I'm in Toronto, I don't feel like moving to Moosonee, and blah, blah, blah. So get it as a contractual term when you're hired, and you won't face this problem. Also, when there is a relocation, the relocation must be to an equivalent position and same compensation, and the company must pay the costs of relocation. There could be a dispute about what those costs are. Sometimes it's documented, sometimes it isn't. And one of the big issues is usually real estate fees, whether the company should pay the real estate fees. But out-of-pocket expenses for sure. And usually there's a month paid for some kind of relocation adjustment or some such thing. But in any event, beware and be smart.